The final step in the constitutional balancing process is to assess whether the separation of powers doctrine permits Congress to take action within its constitutional authority, notwithstanding the potential impact on Article 2 functions. See Administrator of General Services 433 U.S. at 433. See also Morrison 487 U.S. at 691 to 693, 695 to 696. United States v. Nixon 418 U.S. at 711 to 712. In the case of the obstruction of justice statutes, our assessment of the weighing of interests leads us to conclude that Congress has the authority to impose the limited restrictions contained in those statutes on the president's official conduct to protect the integrity of important functions of other branches of government. A general ban on corrupt action does not unduly intrude on the president's responsibility to take care that the laws be faithfully executed. U.S. Constitution, Article 2, Section 3. To the contrary, the concept of faithful execution connotes the use of power in the interest of the public, not in the office holder's personal interests. C1 Samuel Johnson, A Dictionary of the English Language, 763 from 1755, faithfully, definition 3, with strict adherence to duty and allegiance. And immunizing the president from the generally applicable criminal prohibition against corrupt obstruction of official proceedings would seriously impair Congress's power to enact laws to promote objectives within its constitutional authority. Administrator of General Services, 433 U.S. at 425. That is, protecting the integrity of its own proceedings and the proceedings of Article 3 courts and grand juries. Accordingly, based on the analysis above, we were not persuaded by the argument that the president has blanket constitutional immunity to engage in acts that would corruptly obstruct justice through the exercise of otherwise valid Article 2 powers. 3. Ascertaining whether the president violated the obstruction statutes would not chill his performance of his Article 2 duties. Applying the obstruction statutes to the president's official conduct would involve determining as a factual matter whether he engaged in an obstructive act, whether the act had a nexus to official proceedings, and whether he was motivated by corrupt intent. But applying those standards to the president's official conduct should not hinder his ability to perform his Article 2 duties. See Nixon v. Fitzgerald, 457 U.S. at 752 to 753, and note 32, taking into account chilling effect on the president in adopting a constitutional rule of presidential immunity from private civil damages action based on official duties. Several safeguards would prevent a chilling effect: the existence of settled legal standards, the presumption of regularity in prosecutorial actions, and the existence of evidentiary limitations on probing the president's motives. And historical experience confirms that no impermissible chill should exist. Section A. As an initial matter, the term corruptly sets a demanding standard. It requires a concrete showing that a person acted with an intent to obtain an improper advantage for himself or someone else, inconsistent with official duty and the rights of others. Ballantyne's Law, Dictionary 276, 3rd edition, 1969, see United States v. Pasha, 797, F.3d, 1122, 1132, D.C. Circuit 2015, Aguilar, 515 U.S. at 616, Scalia, J., concurring in part and dissenting in part.